And Justice John Gomery joins me in the studio now. Thank you very much for coming in.
Thank you.
I wanted to start by asking you about your acceptance of this job to head this commission of inquiry when you were first approached to do it. Were you apprehensive? Were you hesitant? Did you think twice about doing it?
I have to answer that I didn't. I was impetuous probably and imprudent, and but I was dying to do it.
Really?
Yeah.
Why?
Yeah. Well, I think every judge secretly wants to do an inquiry commission one day. It's a chance to play on a public stage, and perhaps we enjoy that more than we're prepared to admit. And it's a chance to influence policy a little bit. And judges, I think, don't get that occasion, that opportunity very often.
Though we're often criticized for doing it sometimes.
Well, that's right. But really, the possibility to affect the political scene is very limited as a judge. You interpret the law. You may interpret it one way or the other, and you may make a little have an influence on future decisions by what you decide in a case, but really you're pretty well constrained in what you can do. And the chance, as I say, to influence public policy is probably a secret desire of just about everybody. Anyway, it came at a time in my career where I didn't have much else that I could accomplish, and it's a nice way to cap my career, frankly.
Yeah. You realized, I assume, from the beginning what a monumental task this would be. It wasn't going to be a walk in the spring rain, was it?
I knew it would be a challenge. I knew it would be a heavy challenge. I don't think I anticipated how heavy it would be, and I didn't. I foolishly had not anticipated the media attention and the problems that would create, and the stress that would produce.
You didn't think that there would be that much attention after Sheila Fraser's report and the whirlwind around that?
Well, I knew that there was a whirlwind. Obviously, there had been money which had been misspent, and there had been a breakdown in government administration, and I think that was well known. But if you'll remember back, at that time there were a lot of commentators who said that the commission was a waste of time and money, that all the facts were already known, and that there was really no point in spending all this money just to have confirmation of facts that had already been discovered. Now, that turned out to be completely wrong, because the scandal was, I think, much greater than people had anticipated. There was a political aspect to it that was not even hinted at in Mrs. Fraser's report, and I didn't myself know that that was going to all come out. So that and I think it was the misuse, the misdirection of funds to a political party that was the most sensational part of the work of the commission, and I hadn't anticipated that. I don't think very many people had anticipated that that would all come out.
Tell me about how just the logistics of the layout of the inquiry itself, because there were so many players. And for those of us who were obliged to pay attention to it because of our jobs, I just remember thinking at the time, how could anyone who doesn't have to watch this, or even can't, might want to, but can't watch it every day, it'd be like missing 3 episodes of, I don't know, 24 or something, you know? You miss them and you've suddenly a big chunk of the story is gone. So to lay all of that out in advance, I assume there had to have been some path that you wanted to follow.
Well, I had meetings in the preparatory stages of the commission with my legal counsel, and we decided together the general path that we would follow. It was obvious that we were going to have to start by learning, and learning publicly, what the system of government administration is, because you can only learn how it broke down when you know how it's supposed to work properly. So there was sort of an intensive course in government administration that we had to follow. Frankly, I was the student, and the evidence was put before me, mostly by government witnesses, and they worked very closely with counsel and it was presented in a very concentrated form, but then we started getting into the specific facts of the administration of the advertising budget by the by the various government departments concerned, Public Works principally, and there was a sort of a logic to it. We followed Mrs. Fraser's report, but Mrs. Fraser's report broke off at the point where the money left the hands of the government and went to the advertising agencies, and it was that.
That's the limit of her mandate.
That was the limit of her mandate. She had no right to, or no power to, question the recipients of these funds and the persons who, outside of the government, were administering these funds. And that's when the story got very exciting and very shocking.
Yeah. The division between Ottawa and Montreal was done simply for the logistics of those people here in Ottawa that you wanted to speak to?
For that reason, that was a very important reason. I was very anxious from the beginning that this should not be regarded as a Quebec problem, and so that I thought it was a Canadian problem, and so that holding the hearings initially in Ottawa was a little bit symbolic, because we did consider the possibility of having all the hearings in Montreal and getting the various government witnesses to travel to Montreal, and that probably wouldn't have cost more than the cost of having separate offices in Montreal. But as I say, I thought that there was a symbolism that was necessary, that this was an Ottawa problem and therefore a Canadian problem, and not just a problem of some renegade agencies in Quebec.
In the fullness of time, do you think that that symbolic gesture did any good?
I think so. I think that people appreciate that this was not just a problem for the Quebec agencies that were involved, because there were more than just the Quebec agencies. There were others, and no, I think that that was a good decision.
The appearance of then Prime Minister Paul Martin before the inquiry, first time in a very, very long time. In fact, I can't even remember the last year it happened, but it was in the early 1900s, if not mistaken. Tell me a little bit about what I have to assume was the backroom arranging to make that happen. Was it difficult?
It wasn't difficult. His office agreed immediately that he would appear. There was never a question of him being reluctant to appear. He was treated, I believe, like any other witness, except that he was the Prime Minister after all. But he was interviewed before he appeared before me, not by me. I didn't participate in any of the interviews, but he was interviewed by counsel for the commission, and when he arrived with his entourage. Other witnesses might arrive with a lawyer or two, but he arrived with an entourage. So that there were special aspects to his testimony, but essentially he appeared voluntarily. He didn't dictate what questions would be asked. We decided, or our counsel decided, what the questions would be asked. So he was treated like anybody else.
Did you take part in any discussions with your counsel on what questions would get asked, not just of Prime Minister Martin at the time, but other witnesses as well? Were you involved in that?
Generally speaking, no, although occasionally counsel for the commission, or one or more of them, would have a problem about should we bother with this witness? This witness's testimony appears to be, according to them, marginal, and I would generally defer to their judgment on that. But if they were looking for direction from me, there were always questions of timing, of fulfilling our mandate in the time that we had allotted. There are essentially compromises to be made. For example, they'd say to me, it looks like this witness will take 3 days, which means that we'll have less time for the next witness, but we think it's worthwhile. Is that all right? And sometimes I'd say, well, I think it's very important that witness X be quizzed carefully, because it appears that witness X's testimony is going to be in conflict with witness Y's testimony, and I want to explore that conflict. You know, there were sort of strategy decisions to be made, but as a general rule, the council made the decisions.
Now, in a more complex aspect of this, you also had to take into account the type of questioning that would be asked of certain witnesses and the time at which those questions would be asked, given that there were also the possibility of criminal charges being leveled against some of these men, which ultimately there were. How tricky was that?
Well, that was a decision that was made early on, once again, during the preparatory stage. The mandate that I had been given said that there was no, the Commission was instructed not to jeopardize in any way any civil or criminal prosecutions that might be taking place. And we looked at that and wrestled with how we could question witnesses about subjects that were going to be dealt with eventually in criminal trials. And we eventually came to the conclusion that we couldn't. That the best thing, the really only possible way to circumvent that problem was to simply avoid asking questions on those specific matters and be satisfied with questioning them with that. And that was a subject of controversy during the hearings.
Did that make you feel hogtied in any way at all? Like if you're being shackled from really doing what you thought the inquiry was supposed to do?
I expressed myself on that subject in the course of the hearings because there were reproaches that counsel were prevented, for example, from cross-examining Mr. Guite as fully as they would have liked to, and I came to the conclusion, rightly or wrongly, only time will tell whether I was right or wrong, that there were sufficient other opportunities to test Mr. Guite's credibility, and that was the decision not to deal with the criminal prosecutions or the facts giving rise to the criminal prosecutions was the only proper decision that we could make. And as I say, that's a subject that will be explored in the pending federal court proceedings.
Yes. Did you take notes during any of this?
I took notes, but not very extensive notes. We quickly established a system. I wanted to pay attention to the witnesses, and I wanted to pay attention to what was happening in the room. You know, we had a room full of lawyers and cameras and so on, and I thought that if I was busy writing notes with my head down, I wouldn't be able to keep track of what was going on sufficiently. So, but I wanted somebody to be taking notes, so we had a lawyer who worked as my personal assistant throughout the hearings, who was assigned the task of making notes, the kind of notes that I would have made. And she transcribed them at the end of the day and showed me what she had done.
It was like Hansard.
Yeah, a little bit like, except that I continually encouraged her to condense it as much as possible and keep it down so that I'd have an aide-memoire that I could use at a later stage. And those notes were useful to me when it came time to write the report, rather than having to read through the transcriptions. I did some of that too, but her notes were very useful to me.
Tell me about the dynamic of that room. You just described it as being a room full of lawyers with cameras and so on, and all this going on. And I have to assume that that's vastly different than sitting in a courtroom situation.
Yeah. Yes, it is. Well, the difference is that in the courtroom situation, you usually have one person or one or two people who are acting as plaintiffs, and then you have one or two people acting as defendants, and they're lawyers. So you have somebody on the right-hand side of the courtroom looking at it from the judge's point of view, who is the plaintiff, and the defendant. There were no plaintiffs, there were no defendants in this case. There were parties who had interests. Very rarely did two parties have the same interest. So you're juggling with multiple interests, each represented by counsel for those particular interests, and then you have the witness who has his or her own interests. So it's a much more complex situation. You don't know when a witness relates a certain fact, that might affect two of the people in the room and the others not at all, and you've got to be aware of who's going to be affected and sort of keep an eye on them. Are they twitching? Are they about to stand up and make an objection or a comment and so on? It's a much more complex situation.
And you were conscious of those sorts of things, those interpersonal dynamics, if something like that happened?
Oh, I think so, yeah. You know, for example, you quickly learn that each lawyer has his or her own personality. Some lawyers are of one particular way of acting, and another has a different way of acting, and you have to adjust yourself to that. There's no one rule that applies to all. Generally speaking, I was very fortunate. You know, the lawyers that we had in the room were, generally speaking, absolutely top drawer, and familiar with courtroom proceedings, and very familiar with the rules of evidence. And we didn't get a lot of objections and a lot of grandstanding. There was a little bit of it at times, but I have to say that I was agreeably surprised about the way the lawyers behaved themselves. Other commissioners of other inquiries have had a lot more trouble with the lawyers than I had.
You mentioned earlier that you underestimated the media attention on this one. And I guess perhaps you underestimated what would happen if you said certain things in interviews with certain journalists, which is what happened late in 2004, and set off, again, a firestorm, the repercussions of which I think are still being felt. Talk about your decision to grant that interview, to say the things that you did. Do you regret it all now? Do you realize that perhaps you shouldn't have ever done this at all?
Oh, absolutely. I should not have granted those interviews for two reasons. First of all, it would have been better not to have said anything. And secondly, once the decision to grant the interview was made, I was indiscreet about what I said. I was led down the garden path a little bit by Don Martin, who had told us that he was preparing a year-end report on the commission and wanted to have a little bit of a personal look at the commissioner. And I naively thought that he would limit it to that. But when the interview started, he got into subjects which were far beyond just looking at the personal life of the commissioner. He started to ask my impressions of witnesses, and I unwisely didn't say, I'm not going to answer those questions. I went ahead and answered them. That was my mistake, and it was a bad mistake.
Did you realize it at the time, or did you realize it only when it got published?
No, I didn't realize it. I was not alert. I should have been alert to that, and so that was my mistake. It was my responsibility. I made a mistake, and I acknowledged that I'd made a mistake, and as to whether or not it was a fatal mistake is something that, as you say, is still before the courts.
All right. Then let me ask you about Francois Perrault's book called Inside Gomery, which came out last year. He was on this program. We talked to him about it. That book had your blessing, I assume.
Yes.
Why?
Well, I thought it would be interesting. First of all, I believe in freedom of speech. Francois Perrault is perfectly entitled to write a book if he wants a book, whether it has my blessing or not. He's perfectly at liberty to write a book. And when he asked me if I'd write a preface to it, I said, sure, I'll write a preface to it, but I want to have a look at what you're writing. And I looked at what he was having a writing, and I didn't see anything objectionable in what he was writing. I thought it was factual, and I thought it was moderate in tone.
Of course, the lawyers representing Mr. Chrétien are suggesting that he had access to information that perhaps they didn't have access to in order to put it in his book. That has, in recent federal court ruling, seems to indicate that some of Mr. Perrault's information and papers and related to his mandate will have to be turned over because that may have been the case. Do you think about that at the time?
I'm not going to comment on Mr. Perrault's book. It's it's a subject that is before the courts, and I think it would be better for me not to say anything about it.
All right. All right. Let's talk about how ugly this really did get when people started going after you and your daughter. And I'm curious as to your initial response to that. There were suggestions on certain blogs from people who were supporters of Mr. Chrétien suggesting that Ogilvy Renault was given the contract as being the lead counsel for the commission simply because your daughter was a lawyer with that firm. And that back and forth went on out there for a long time. Were you surprised at that level of, for want of a better word, viciousness?
Well, I was dismayed by it. I thought that that was, first of all, I thought it was basically a nonsensical allegation, so I thought it was sort of dirty fighting. But I had anticipated that it would be impossible to keep politics out of the commission, given the mandate that we'd received, and I knew that politics is a blood sport, and that there would probably be some ugly moments, and that was one of the ugly moments.
Did you discuss this with your daughter at the time?
Well, we talked on the phone.
Yeah.
I told her that I thought it was too bad that she found herself on page 1, and
Was she upset by it?
she was less upset about it than I was.
Really?
Yeah, she's a very philosophical, level-headed girl, and she shrugged.
Yeah.
You know, she thought it was a bit of a farce.
You have said that you're a person of routine and habit and so on, and that I guess this stood you in good stead when you were going through the months of this thing. Mm-hmm. Just talk a little bit about that then. Let me do what Don Martin said he was going to do. Let me ask you about that routine that you used, because these hearings went on day after day after day, month after month. I mean, just physically, it must have been a grind.
Well, my wife is a very astute observer of me, I guess. And when before an audience of judges, she described how I coped with stress. And she said he copes with stress by establishing a routine and takes refuge in his routine. And she's absolutely right about that. I do have set habits, and that, I guess, is a way of protecting myself against the outside world. I get up at the same time every morning. I eat the same breakfast every morning. I walk to work almost always. I eat my lunch alone. I have usually take a little walk at lunchtime. I study my papers at a certain time. I stop working at a certain time in the evening because I know that I've emptied the reservoir and it's time to refill it. So and I'm able to. I work, I think, rather intensively when I'm working, and then I stop working altogether. And this is a fortunate capacity that I have.
And when you say you stop working, you can literally clear your mind of that stuff?
Yeah. I can't think during all of the months and months of the hearings, for example. I didn't suffer insomnia except for maybe a couple of nights at the time I was being asked to recuse myself. But apart from that, I sailed through it but you wear down over time, you know, because it is intense and it's in your mind all the time. You sort of live the commission. Speaking of my wife, I was an absent husband in the sense that I was not really a companion to her. I was preoccupied all the time with the commission.
I can imagine. Do you recall then, when you said that you realized that once it got beyond what Sheila Fraser's mandate was, and when the inquiry got into the other end of things, do you recall moments sitting there in that chair with witnesses in front of you saying certain things that left you stunned?
Yeah, I was stunned. I think everybody was stunned.
Many times?
Well, quite a few times. Yeah, quite a few times. It was very dramatic, you know. I mean, I'm not going to talk about specific incidents, but there were hearing stories about envelopes stuffed with cash passing from one person to another, and with meetings in restaurants where transactions were being discussed that sounded like some film. It was very dramatic,
yes.
And it had the ring of truth to it to a large extent. Certain incidents had the ring of lies to them, but it was very, very dramatic, and I was awestruck by what was coming out. I had not anticipated that we would have the kind of revelations that we had when I started. when Mr. Martin said that he wanted to get to the bottom of it, I didn't know that how deep
the bottom was.
deep the bottom
Yeah.
was. Yeah.
Mr. Coffin, Mr. Bro, Mr. Guite have all been charged and found guilty of various offenses now criminally. Mr. Chrétien's lawyers, in their arguments against your findings, have said that you chose to believe certain people and not believe others. And they point out that, and I guess they could point it out even more now, that those three men in particular, you chose to believe certain things that they said and not to believe things that other people said. Now, I ask you this as a judge working in the judicial system, when I suppose that there are times when you're listening to one witness impugn the credibility of someone who's been charged with something, and that witness has just as probably a spotty background as the person who's being, the charges of whom are against. So in this case, were you apprehensive at all when you had to make your final decisions as to who to believe and who not to believe, that some of the, for example, some of the things that Mr. Guite said that you chose to believe, that they were actually true? Were you worried about those things?
I wasn't worried about them because I have confidence that the conclusions that I came to about credibility of witnesses were well-founded. I didn't have any difficulty in coming to those conclusions. A witness who is an unreliable witness, because that witness sometimes doesn't tell the truth, it doesn't mean that everything that that witness says should automatically be discarded. When you have an unreliable witness, when that witness makes an affirmation, you should examine it very carefully because you know you're dealing with an unreliable witness. But even an unreliable witness may sometimes tell the truth. And the whole system of justice is based upon a search for the truth. You sometimes, when you're dealing with unreliable witnesses, look for corroborating evidence, you look for the surrounding circumstances, you look for what other witnesses have said, and you look for documentary evidence. There are lots and lots of ways of testing the credibility of a witness. The idea that because a witness has told a few lies, or many lies, that everything that that witness said should be thrown out into the ash can, I don't think that's a valid proposition. In any event, I explained as fully as I thought was necessary the reasons why I came to certain conclusions about credibility of witnesses in my report, and I stand beside those findings.
Were those final decisions made in collaboration with your counsel,
No.
or that was you?
No, that was me.
That was you.
That was me entirely. Well, I'm not going to go into too much detail, but at the end of the hearings, I took about a week to resume, mostly in my mind, by looking back on who I was going to believe and what aspects of certain evidence I was going to believe. And I came to my conclusions quite quickly as to where the truth lay. And I announced those conclusions to counsel, but I didn't ask their advice, nor did they question it in any way. They behaved very properly, I thought. I just said, I'm going to accept this and this and this, and I'm not going to accept this and this and this, and so I'm going to start writing the report along those lines. And they said, fine. But there was never any debate about it.
This could be one of the dumbest questions I've ever asked somebody, particularly given that you are a judge, but from whence comes your certitude? How do you make that decision? Do you know, is this just habit because you've sat as a judge for so long that you make a decision and you're comfortable with that decision? You don't second guess yourself?
Well, first of all, you're assuming that it's a habit that you acquire as a judge. I'm going to suggest that you start to learn about the search for truth as a lawyer. One of the techniques that you learn as a lawyer is to cross-examine, to examine, cross-examine, and you start to spot quickly as a young lawyer and as an experienced lawyer the indices of where the truth lies and where the truth does not lie. It's not hard to spot a lie. I know that people say, gee, how do you decide? And I'm sorry, you say it's a dumb question, I'm going to give you a dumb answer. It's not hard. It's usually pretty obvious when you think about it. If you make an analysis of what a witness says and the way the witness says it and the surrounding circumstances, it's not hard to spot a lie. And it's not hard to spot a truth if it's well established and if it's evident. It's a matter of common sense, you know. But I think judges have a better basis for common sense decisions than other people, because this is what we do for a living, is we look for the truth and we learn to identify who's done it, so that it's perhaps easier for a judge because it's what you do all the time.
All right, let me ask you one last question, and that has to do with where this inquiry and its two reports end up in the history books, because they will. Going into it, I guess you probably didn't realize the impact this would have, but it certainly has had a major impact on the political life of this country. It changed the government, essentially. It may have more impact down the line. How does that make you feel?
Well, I'm very proud of that, to be honest with you, because I think that, generally speaking, the effect has been beneficial. I mean, aside from the political effect, the population of Canada looks after the election of its representatives, and I have nothing to do with that. That's the individual decision of each voter and so on. But the effect upon the administration of government, that's called the Gomery effect now in government circles, I think it's been largely and predominantly a beneficial effect. I think that public servants are a little more cautious about what they do right now, and I think that's a good thing. I think that they should think about the consequences of what they're doing. I think that there is a trend which has been assisted by the so-called Gomery effect, a trend to greater transparency in government. I think let the light shine in. I think it's good, and I think that that's the days of decisions, government decisions, being all made behind closed doors is going to become a thing of the past. And I think that the Commission has had an influence on that. And the whole idea of better ethics in government has to be good, eh? And if I've given a little push in that direction, I'm happy with that. I'm proud of it.
Awfully good of you to take all this time. I appreciate you doing this. Thank you very much.
Pleasure to talk to you, Ken.
Thank you. That was great. That's it for this edition of Talk Politics, and that's it for us for this season. Over the course of the summer months, we're going to be replaying some of our favorite shows from this past season, and we'll be returning with new shows in September when the House of Commons comes back. Thanks very much for watching. I'm Ken Rockburn. We'll see you then.